Good morning, everybody. Thank you very much indeed for joining us for this, our fourth AGM Season Report in 2020. Thank you very much again for joining us, everyone, in this, our fourth AGM Season Report in 2020, a most unusual season. And this is the first time that we have presented it virtually. We have a very large attendance, and we're looking forward to some sharing a question and answer session with you later, and a panel discussion and hearing your own questions. So I will introduce those who are appearing before you this morning. Myself, Justin McKenna, and my colleagues Anne Harkin, who will be presenting our report, and David Mangan and Paul Egan, who is also the chairman of the CLRG, Company Law Review Group, and who I'm told is personally responsible for all of the company law amendments to do with COVID-19 in 2020. And just a little bit of a spoiler alert, given the unusual season that we've had, there is some COVID content. It's difficult to avoid that, I'm afraid. And in fact, it has been very influential in the conduct of the AGM season in 2020. I'm also delighted to say that we're joined by two very distinguished guests from Computershare, and they are Joe Maloney, who is Client Service Director. And even though his youthful experience will belie this, he has been with Computershare for over 20 years. He has over 20 years experience in the share registration, business relationship management and business development. He joined Computershare in 1998 and was appointed Client Services Director in February 2015, having held various senior positions across the registry business over 17 years previously. His current role incorporates responsibility for industry issues, as well as leading the client relationship teams for share registry, corporate actions and dividends. And that is pretty much everything that is involved in client relations, share registry, corporate actions and dividends. That's client facing and not back end. He also sits in a number of industry working groups, such as the Irish Market Advisory Committee, the Stock Events Working Party, and the Market Implementation Group, which is, as we all know, overseeing the migration of all Irish corporate equity securities to a new CSD run by Euroclear Bank in March 2021, according to the current deadline, which is not absolutely fixed in stone. And we're also joined by his colleague John Britton, who's Governance and Industry Officer. He's worked with Computershare for over 12 years, having effective roles within asset reunification business, client management, specialising in depository interests and corporate-sponsored nominee clients. And before becoming the Governance and Industry Officer for Computershare's Issuer Services business, where he provides insight and works in industry matters and changes to internal and external stakeholders. He's an associate of the Chartered Institute for Secretaries and Investments, a member of the ICSA, Chartered Governance Institute, and is the current secretary of the ICA's Registrars Group. Some of his choice, HSBC, NatWest and Rio Tinto. And we're very much looking forward to John's insights in relation to practice in the UK as compared to in Ireland. So without any further ado, I'm going to ask Anne if she would please start the presentation on 2020 AGM season.
Thanks very much, Justin. So as Justin mentioned, this is our fourth year looking at completing this report. The purpose of the report really is to look at the resolutions that are typically proposed by listed PLCs during the AGM season and see sort of what statistics or trends we can pull from those resolutions and the results that those resolutions achieve, and hope that that might provide some useful guidance for companies in the subsequent year when planning their AGM or coming up with the content for their resolutions. We also look at the various sources that dictate the content of the circulars, so the Companies Act, listing rules, and also proxy agency guidelines such as ISS, Glass Lewis, PERC, the Pre-Emption group. There were 25 companies the subject of our review this year, those being the main market, Irish incorporated companies with a main market listing on Euronext Dublin or the London Stock Exchange. The reason that we focus on these companies is that they are obliged to given a detailed breakdown of their voting results after the AGM. So there's a lot of statistics or information that we can pull from that. As Justin mentioned, this has been a very interesting AGM season with COVID-19. So part of our report and a number of our slides at the end here will deal with aspects of the AGM that were impacted particularly by COVID-19 and sort of what statistics and information we were able to pull from that. So the first topic that we look at is remuneration. So this is the Remuneration Policy and Remuneration Report. So during the year, we had the introduction of the European Union Shareholder Rights Regulations, which came into effect on the 30th of March. They are the transposing legislation for the second European Shareholders' Rights Directive, and they, for the first time, give statutory basis for Irish shareholders to have a vote or a say on directors' pay. Now, up until the introduction of these regulations, there was a high level of voluntary compliance with the UK Companies Act, which required a vote on directors' remuneration policies and reports. But as I said, this is the first time that it has a statutory footing in Ireland. So the way in which the legislation or which the second European Shareholders' Rights Directive has been transposed is such to give shareholders a vote on the remuneration policy once in every 4 years by way of an advisory and non-binding resolution, and in respect of the remuneration report, also an advisory and non-binding resolution, but annually. Now, this applies only to financial years commencing after the 10th of June 2019, so not all companies were in scope this year. So in terms of the statistics that we were able to pull from that this year, we see that 52% of companies put forward a resolution on their remuneration policy. Now, bearing in mind that this the requirement is that there is a vote every 4 years, and for prior to 2020, a lot of companies would have been complying with the UK requirement of a vote every 3 years. 52% is quite a high percentage. You'd be expecting that most years to come in around the 33% mark. All resolutions were classified as a non-binding and advisory, and overall there was a very high level of approval from shareholders, with 12 companies receiving 90% or more, and only one company actually receiving a significant vote against. And that was Green Corporate PLC, and they did issue an announcement post the AGM noting that consultation had taken place with shareholders, and the reason for the significant vote against was due to discrepancy between pension contributions for executives and the overall workforce. On the remuneration policy or remuneration report, we had 84% of the companies we reviewed put forward a vote, which again was quite high given that not all companies were in scope this year, given that it only applied to financial years commencing after 10 June 2019. Again, very high level of approval from shareholders, with only 2 companies receiving a significant vote against the resolution. One of those being Ryanair, who for the number of years now have had a significant vote against this resolution from shareholders. Again, each company classified this resolution as advisory and non-binding. Just very briefly on incentive plans, this is something maybe we expected to be impacted more by COVID and maybe not see new plans being put forward this year, but that wasn't the case. 28% of companies proposed a resolution for either a new plan or an amendment to the existing one, which is broadly on par with other years. So 7 companies this year, 7 companies last year. The majority of these were for new plans, with only 2 of the resolutions actually relating to amendments to existing plans. And again, very high level of approval from shareholders for these resolutions. The next topic that we look at is directors. So there's a number of things that we look at, or statistics that we try and pull from the resolutions to re-elect directors. The first thing we look at is whether all directors were put forward for re-election in accordance with the UK Corporate Governance Code, and that was the case. This year we had 100% of the companies we reviewed put forward all of their directors for re-election. The next thing we looked at is the overall approval rating for directors that were put forward. And this year we saw actually an increase in the approval rating for directors, a significant one. So there were 235 directors put forward for re-election by Irish companies this year. Of those, 218 received an approval in excess of 90%. So that was up from 208 last year and 217 the year before. There was only 4 directors who received approval of less than 80% in comparison to 8 last year and 6 the year before. So we think that the sort of trending for higher levels of approval is partly due to companies paying closer attention to what proxy agencies are saying in terms of some of the factors that they look at when considering voting recommendations for directors, such as issues like overboarding, independence. Just thought it was interesting maybe to pull out the 9 directors who received 85% or 15% or more of a vote against them. And just in that, it's interesting to note that the same director appears twice on the list, and that's Michael Cawley, who's the director of Kingspan and Ryanair, and also I believe holds the directorship on Flutter Entertainment PLC. So I think this really emphasises the fact that overboarding, or what proxy agencies are saying, does come back and can be seen in the levels of approval for certain director re-elections that we see on an annual basis. Another topic under, I suppose, the subheading of directors is gender diversity. And in particular, what we look at here is female representation on Irish boards. And I'm pleased to report that this is something that's trending very positively. So this year, there are 29% of the seats on boards of Irish listed PLCs are held by female directors. This is up from 25% last year and 19% in 2018. So we've only looked at this statistic for 3 years. And in the 3 years that we've looked at it, there's been a 10% increase in the number of female directors. Aminex PLC is the only company at the minute which has an all-male board. And actually AIB Group PLC is the only company which is comprised of a majority of female directors. Now, we look at this statistic at a certain point in time every year, just before we publish the report. So we can't really comment on fluctuations in board composition throughout the years. But in the 3 years that we've been looking at this, this is the first time that we've seen a board having a majority of female directors. So that's a positive and interesting trend to note. Just before we move off from the topic of diversity, it's just worth mentioning a few of the updates that some of the proxy agencies have made to their guidelines for 2021. So Glass Lewis have noted that they'll generally recommend a vote against the nomination committee share of FTSE 350 companies that have failed to meet the Hampton Alexander 33% board gender diversity target. ISS has made a similar update to their policy, and they've also noted that in respect of AIM companies that have a market cap in excess of 500 million and FTSE small cap companies that where there's not at least one woman on the board, that they will recommend a vote against the nomination committee chair. The next topic that we look at is share allotment and pre-emption authorities. So 100% of the companies we reviewed put forward a resolution for a general authority to allot shares. Similarly, 100% of companies put forward some form of resolution in relation to disapplication of pre-emption rights. So the pre-emption guidelines, the pre-emption group principles here are very, can be seen in a lot of the resolutions that put forward. Only 28% of companies went for a 5% only authority, with the majority of companies now, 72%, seeking an additional 5% to be used in accordance with the pre-emption group statement of principles. So this is a significantly higher percentage of companies looking for that 10% authority than we have seen in other years. So you can see from the statistics on the slide there that typically it's about 60% of companies that look for this additional 10%, or the additional 5%, bringing it up to 10%. There was relatively high shareholder approval for these resolutions, with just one notable dissent there from Aminex PLC, where they only received 12.5% shareholder approval, so the resolution didn't carry. Just worth mentioning some of the COVID guidance from proxy agencies around pre-emption authorities. So in April of this year, the Pre-Emption Group issued guidance in relation to its expectations for issuances in light of COVID-19. And they noted that on a case-by-case basis, that they'd recommend investors consider issuances of up to 20%, just in light of the situation that certain companies might find themselves in. ISS, in the guidance that they issued in the middle of the year in light of COVID, just noted that they would apply their existing sort of policy framework with adaptations to take account of local market relaxations in respect of pre-emption disapplication. So Finally, what we want to move on to is look at some of the aspects of the AGM that was particularly impacted by the pandemic. So the main things that we looked at here were the timing of AGMs, shareholder attendance, so was it a closed AGM or was it a location of the AGM moved, dividend resolutions, and the ability to hold virtual and hybrid meetings. So just on timing, so the legal requirement here is that under the Companies Act is that an AGM must be held within 15 months of a company's preceding AGM. During the year, we had the introduction of the Companies Miscellaneous Provision COVID Act, which gave a general extension for the time limit to holding AGMs to the 31st of December. Now, this act only came in August of this year, so at this stage, and you'll see from the statistics further down, the majority of companies had held their AGM, or at the very least had posted their notice of AGM. So we weren't really able to see whether any company relied on this because it just really wasn't applicable for this AGM season, and will be more relevant next year if there's any, I suppose, further extension of these provisions. Because obviously at the minute it's up to 31 December 2020, so we wait to see whether there'll be something similar for next year, given that we're still find ourselves in the pandemic, and this looks to go on for into the AGM season next year. In terms of postponements or adjournments, this was a statistic that surprised us. We were expecting it to be higher here. There was actually only 3 companies who postponed their AGM from the date that they would have originally announced at the start of the year. 4 other companies held adjournments, but they were just adjournments on to a different location on the same day. So not a very high level of number of companies actually postponed their AGM, with most of them seeming to proceed at the date that had been originally scheduled at the beginning of the year. We always look every year at which month is most popular to host an AGM. May is always the front runner, and that's broadly similar this year. May and April were tied in first place here, with July coming in close behind. And we think, so I suppose that July was more popular this year. They're probably the 3 companies that adjourned or deferred it until July. Days for AGM, just Wednesday is the most popular day, and that's sort of been broadly similar to other years, with no AGMs being hosted on a Monday. The next thing we looked at is whether shareholder attendance was permitted at the AGM. And again, this was a statistic that actually surprised us because we were expecting the figure for closed AGMs to be much higher. But when we actually looked into the wording or the recommendations that were made by companies in relation to shareholder attendance, not all of them went as far as holding a closed AGM. So of the 25 companies we reviewed, and the 23 of those that actually AGMs fell within the COVID sort of pandemic, 2 of them had their AGMs in January. Only 9 had a truly closed AGM, and this is where they used language such as shareholders are prohibited or will not be allowed entry to the venue. The majority of companies, so 56% of companies, used kind of a combination of wording such as strongly encourage or strongly advise against attending in person and recommending a submission of proxies in advance. So that was I suppose, the position that the majority of companies have taken. So it'll be interesting to see what this is like next year if we find ourselves in further times of lockdown or restrictions. Just in terms of location of AGMs, so this is something we usually look at every year to see which hotel fares the better. Is it the Graf, is it the Shelbourne or the Westbury? But this year, of the 23 companies whose AGM fell during the pandemic, 20 of those hosted them in their corporate offices or HQ, with only 2 companies using hotel venues, and one of those was actually for a closed AGM. So I think it was Ryanair was the only one who held their AGM in a hotel venue this year. With one other company using their lawyers' offices. Dividends is another area which has been impacted by COVID. So as you can see here, only 36% of companies declared a dividend this year, which compared to last year, which were up at 59%, it's usually a 60% figure that we see. So that's about half. There were 3 companies who had a dividend AGM on their notice of AGM and subsequently withdrew it. One company, being Flutter Entertainment, they carried on with their dividend resolution but noted it would be settled by way of a bonus issue of shares. AIB, actually, who for the first time since the financial crisis declared a dividend in 2019. It and Bank of Ireland Group put out announcements earlier in the year just noting that in line with the European Central Bank recommendations, they wouldn't be proposing any dividend resolutions this year. Other companies who typically would propose dividends would be SVD and Irish Continental Group, but they put an announcement out much earlier in the year, so before they even came to posting their notice of AGM, just noting that they were abandoning their plans to declare a dividend. So this is an area that was definitely impacted due to the pandemic. Just going to briefly mention virtual meetings because it's going to be the subject of some of our panel discussion in a while. But it's just worth noting that for the first time in Irish law, you can now hold a true virtual general meeting. This is available for an interim period only until the 31st of December of this year, but we're looking to see whether that will be extended, and there may be some discussion on that during our panel talk. So this was brought in by the Companies Miscellaneous Provisions Act, and which I mentioned earlier only came into effect in August of this year. So really we can't comment on it in respect of this AGM season because it was too late to really impact it. But it's just worth mentioning some of the proxy agency guidance that is out there in respect of virtual AGMs. So during the year, ISS put out a specific guidance note in relation to COVID, and just noting that while they generally prefer hybrid meetings as opposed to truly virtual meetings, that they were mindful of the risk created by the pandemic, and that that they wouldn't be making adverse voting recommendations in relation to virtual only meetings until such time as it's safe to hold in-person meetings. Now these COVID guidance notes that the ISS issued were for the 2020 season, and it's notable that they haven't updated their policy in virtual meetings for the 2021 season, but you would imagine that I suppose the fact if we still find ourselves in the middle of the pandemic next year during AGM season, that the same principles would apply, or that they would be of the same view. Glass Lewis has updated its policy on virtual shareholders meetings and the factors that it will consider when making voting recommendations. So they've been updated in their 2021 policy updates. So that's everything from me. Sort of a whistle-stop tour of some of the statistics that we've been able to pull out. The full report will be shared with everyone on the webinar once we wrap up. Just to flag, there's a number of other headings we look at in our reports, such as share buyback authorities, continuation of the office auditors, remuneration of auditors, amendments to articles, convening EGMs in short notice. So, and we obviously go into a lot more detail on the statistics that we've already run through. So with that, I'm going to pass you back over to Justin and David, who'll kick off our panel discussion today.
Thanks very much, Anne, and fascinating. And by way of general observation, I'm kind of pleased to see how resilient the markets have been in terms of business as usual having been conducted. And indeed, it has been a very disruptive year. We found ourselves having, looking at notices of annual general meetings, facing into possible restrictions which were possibly not going to come in place, or even having new restrictions coming in place. And there were a smorgasbord of different restrictions applying at different times, such that at one stage I wasn't even sure whether you were allowed to have an AGM if you issued everybody with the €9 fish and chips vaccine and allowed them to have a pint or something. But it was a very confusing year. Nevertheless, business as usual continued. Also, virtually no impact of the August company law amendments as yet. So I think at this juncture, I'm going to ask David to maybe kick off the panel discussion on some of these really interesting issues that have been raised from the statistical analysis.
Thanks, Justin. So perhaps I'll start with Joe as the Irish expert in the practical running of AGMs. So what was different about running AGMs in the 2020 season?
Yeah, I mean, I think, describing our experience about running those AGMs, I think it's a good question. In general, the meeting season went quite well, David, bearing in mind the COVID restrictions that we experienced, quite a bit of prep had to go into the meetings. And while, this is always the case, it was a different type of prep, it's fair to say, as companies prepared for remote support. I think issuers needed to consider their quorum was organized for the actual meeting. It's not something that they would generally have thought about, I think, in the past, in relation to an open meeting. Other things like, polls, I mean, they ran quite smoothly, smoother than expected, to be honest, but issuers needed, time to gather, the poll cards, because they were being managed really in a sense. If we were supporting remotely, which in the main we did due to the health restrictions, there was an electronic solution that needed to be facilitated there, and additional time was set aside to manage all of those requirements. I think other points that were reasonable to point out: availability of the chairperson, who wasn't resident in the state. That was a consideration for a few issuers, as they would normally fly in on the day. We saw a number of issuers appointing alternative chairs for the purposes of the AGM. But I think it's good technology is key, making sure that you've good, clear means of communication, and that's functioning, whether it's remote online facilities, good Wi-Fi, essential. It's essential, and the backup then that you have. I mean, whether it's telephone, audio, or whatever the case might be. Telephone support was a key thing for quite a number of the coast sects, because they were experiencing it, themselves, and doing some of the things that we would do in the meeting, but having us as support was
yeah. I mean, there's certain things from Anne's report you can see. AGMs tended to go ahead on the dates that they were already scheduled for.
Yes.
Though our experience for companies outside the regulated market is slightly different. I think Euronext Growth and AIM companies were more likely to defer, mostly because they had to announce the date. But as Anne says, it was a bad AGM season for the Westbury Hotel. So can you tell us a little about these closed meetings or semi-closed meetings? How do they work?
Yeah, sure. I mean, they worked again. They worked reasonably well. I mean, the vast majority of issuers proceeded with their meetings as closed, as opposed to postponing, and were happy. I think they were happy that they did so. We did find that those issuers that postponed, in hindsight, they would have preferred to have held the meeting as per their original timeline. If I'm being frank, I mean, the reason for that was the restrictions lifted. It was a grey area as to whether they should allow attendance, albeit on a restricted basis, or continue with a closed meeting, as it would be frowned upon, given that the local guidelines, etc., were allowing up to 30 people. But practically, I think having the technology again is essential, as in most cases, we are supporting remotely, and registers, are available online as needed. And we would have had 2 client managers, indeed, supporting the needs on the day, and again over the phone, email through our online systems. I mean, a physical copy of the register was important, that the issuer had that on hand, and that was supplied and on site with the COSEC team and managed as required. Issuers would advise who was in attendance, and we would record the detail as necessary. Again, I mean, worthwhile pointing out, communication to shareholder is important, because they need to know that the meeting is closed. And other practical matters, such as having a company representative on hand, either to hold share or has been appointed at least as a third party corporate rep, should one of the attendees not be in a position to attend, which we did have experience of. But it's good to have live audio and streaming facility. Questions can be collected beforehand for answering, and all of those things, or else raised throughout and answered afterwards, which is was facilitated. I think it was important that was made available to.
But on the technology, you're talking about one-way audio. This is
yeah.
So no live questions and answers on the.
We didn't experience that. I mean, that would have been more. I mean, if you were, the virtual aspect would have kind of brought that into play, I think, a little bit more, David. But it was one way in that sense. Yeah.
Actually, Justin, can I turn to you for a legal comment? Views on the fully closed. This is a closed meeting type of meeting, and the semi-closed. We encourage you not to turn up. What's the legal status?
the August amendments to the Companies Act have not improved the position with respect to holding semi-virtual or closed or semi-closed meetings, because the most recent amendments sit on top of the Companies Act, but they don't belie or change the underlying provisions. So if save to the extent they allow exceptions for the manner in which meetings are held. So if you decide not to hold a meeting in compliance with the 2020 Act, you don't have the protection of the 2020 Act if it is not run in compliance with the Companies Act. And as we know, there was a challenge to the Grafton Group AGM earlier in the year. And in that challenge, in which Michael Chadwick sought an injunction to prevent the meeting going ahead, the result was that the meeting was permitted to proceed, but it was the reason for that was balance of convenience, I believe, and the fact that not many shareholders had objected to the manner in which the meeting was being held. But the clear implication of that was that had there been a number of shareholders or a majority of shareholders who had objected, the court looked like it would accede to the request. And when you overlay on that the fact that there was an alternative, or there is now an alternative, which is a virtual meeting, you'd have to say that the position of the board in deciding to hold a closed meeting when there's an alternative available potentially makes that more vulnerable to challenge. Now, I think the next test for this is going to be the dozens and dozens and dozens of migration AGMs which are coming up, but maybe not a proper test, because as we all know, those meetings are binary yes-no decisions. Do you want your company to continue to be able to trade its securities on the London and Dublin markets? So it doesn't seem to be in anybody's interest for a shareholder to challenge that. As against that, you'll have seen the CPL Resources scheme of arrangement meeting is being convened on a virtual basis. And I guess that's because it's a court-convened meeting, which means that it's designed to avoid any risk whatsoever that it might be called by the court in a manner which wasn't compliant with restrictions. So I think the situation is unclear, and there is some risk in closed and semi-open meetings.
But you're from the sounds of it, your view is it probably doesn't work to tell members that a meeting is closed and to turn them away using that closed meeting language.
It probably doesn't work from a company law perspective. I mean, there is the underlying the restrictions which have just expired made it a criminal offence for a person operating a business premises to allow persons onto those premises for other than essential purposes which are specified in the regulations. So there's a big conflict there. So you're faced with a company law obligation and a criminal offence if you comply with it. So yeah, I just think the current situation is subject to doubt, and if those restrictions are reinstated, then it simply doesn't work.
Yeah. So, Joe, we already talked about the COVID Companies Act, which came up, which only arrived in August. But are we seeing any impact yet? Are we seeing people using the new ability to run virtual hybrid meetings?
The short answer is no. As issuers haven't taken that leap of faith. Noting, just in mentioning, a CPL in that sense, but I think we are seeing only, as I say, that one issuer look at that virtual option. But I believe there is a general nervousness, I think, David, it's fair to say, about being the first, and possibly if the legislation, is extended, we may see others, I think, take that leap of faith into that virtual option. I suppose, in a sense, it's only there since August. So that change of behaviour for people, they haven't had enough time to consider things. But we are seeing, issuers take steps to change articles, and I think it'll be interesting to see, and again, as Justin alluded to, in the first quarter of next year, when we see, all of those issuers have the EGMs to pass the appropriate resolution to migrate into the CSD. That's something that we could see used, and whether that longer term, will change behaviour, it'll be interesting to see. But as it stands, there hasn't been too many that have gone down that route. I think, there's a nervousness around it, I would say.
Yeah, we might get into that with John, who has experience from the UK, but just generally on the Irish rules, is there a feeling that that the technical standards and the other requirements for running a virtual AGM are too onerous, too difficult to comply with? Is that part of the reason for not holding them, or is it just a lack of time since August?
I think it's largely the lack of time since August. Being straight up about it. I mean, there are other things. I mean, the technology is going to be very important, and how that is supported. Allowing the issuer speak and be heard. At least a shareholder in that sense is there's aspects of that people will just need to get themselves comfortable with, I think. But yeah, I mean, I think John probably would have some views on that from the point of view of UK experience.
Yeah. So John, actually, can you introduce us to what's been happening or what's possible in the UK for a number of years now?
Yeah. So in the UK, under the Current Companies Act, we are permitted to certainly use more technology. There's been some legal challenges about whether fully virtual is permissible, but because of the UK temporary COVID legislation, that went away and will be sort of gone away until at least March, because the UK has now extended their legislation. But when it comes to virtual meetings, all hybrid meetings, the UK hasn't seen a huge amount when compared to other places in the globe. When you look at somewhere like the US, who have gone from, I think, 300 last year to over 2,000 this year. But there are some things that you've got to remember whether you're going to do the virtual or hybrid solution. And one of those first things is getting comfortable with the technology, as Joe has said. The technology is proven now, but it's for the COSEC teams and the board of directors to feel comfortable with it. So it's worth having run-throughs of that technology, regardless of which provider you use.
So as a practical matter, how do they run? How are they typically run in the UK?
Yeah, so they're not dissimilar to a normal physical meeting in many senses. You provide your shareholders with clear information on how they access the technology. For most meetings, it is a secure access, so they will use things like a shareholder reference number, your name, the sort of information that's retained on the register of members so that you can be validated as an actual shareholder. And then once you're in the meeting, you'll be able to view the webinar or the presentation being given by the board. You'll be able to see the questions that are being raised by members, usually on a text functionality. And if you have the voting facility as well, once the chair opens the vote, you'll be able to then vote as you would on a handset meeting or a physical poll card meeting. And it would be up to the board and the COSEC team as to whether they displayed the results immediately, as you see with some handset meetings, or whether they publish the results post-meeting, as you would often see with a sort of poll card meeting.
So are you talking about two different bits of software, the communications and the voting, or is it integrated?
Depending on who your technology provider is, it can either be integrated or a lot of them will allow you to mix and match software. If you look at someone like Lumi, who is the predominant supplier at the moment, but I think that will change as more markets push forward with virtual and hybrid solutions. Theirs is an integrated solution, so you can do it all through one platform. And
as soon as you start talking about services, start talking about expense, does the expense work? Obviously, for the largest companies, it's probably feasible. AIM-listed companies, does it start to be less affordable, or is it cheaper than a hotel?
It's probably cheaper than renting a hotel, depending on the size of the room you usually rent. But I think I think what you've got to kind of consider is whether you're having a virtual, as we would understand it, to be completely all-encompassing, or whether actually you want just more in sort of a more interactive meeting. So in theory, if you're not doing voting at the meeting, you could use a platform such as Zoom, which of course then the costs are a lot less for you as a small company.
Brings us to an important difference with Ireland. You have to provide our interpretation of the slightly vaguely worded provision of the COVID Companies Act is that voting must be available, electronic voting must be available. So it's not really an option not to. And just speaking generally then about shareholder engagement in general, how does a hybrid or virtual meeting feel from the point of view of shareholder engagement?
So I think it's kind of all dependent on your view as a shareholder. You know, we have seen a number of shareholder groups throughout the AGM season become more comfortable with using technology because they felt that closed door meetings really did shut down their ability to hold the board to account. But I think going forward into the future seasons, when closed door meetings are really going to be frowned upon in most markets, particularly if you look at the likes of ISS and Glass Lewis's recommendations, and even some of the big shareholder groups or investment funds. So I think shareholders will find it different, and issuers need to be cognizant of that, and whether submitting questions via a written text service is really sufficient. They may have to consider having conference facilities, which add extra expense, and they have to be clear and thoughtful about communicating how they're going to moderate or group questions that they might receive during a live meeting scenario, because that's certainly one of the biggest concerns that was coming out of the likes of the US market and some of the European markets when they were conducting virtual meetings over the 2020 season.
They felt they were too short. They didn't answer enough questions.
Yeah, didn't answer enough questions. There were restrictions on characters that could be used. Questions were grouped and shareholders didn't know that they would be grouped together. So the board would give a generic response rather than a specific response per question. And it's some of those things that companies really have to be clear about what processes and procedures they're going to be using for their meetings.
And Justin, you were pointing to some academic work on running virtual AGMs versus physical, kind of points in that direction.
Yeah, there was a very interesting article in the Financial Times in September on this, and it also referenced an academic report, which, as I mentioned to you, was 57 pages, and I didn't read all 57 pages, but I did read the summary, and the summary indicated that there was a significant amount of dissatisfaction with virtual meetings arising from the 2020 season in the US, and some of the concerns included those mentioned by John, but also, if you like, the virtual meetings being used as a facility by boards to dodge answering questions. So, and it being very difficult for shareholder groups to monitor the extent to which questions were being just simply ignored or as John mentioned, conveniently grouped. So, you know, there are some advantages for a virtual meeting if you want to get through it quickly and manage the process and not necessarily engage with shareholders to the extent that might otherwise be appropriate if the board is so disposed. So I can see there is a basis for that level of criticism. It hasn't arisen here yet, as far as I'm aware, simply because there have been no virtual meetings of larger companies anyway. So yeah, I think this is an evolving process. And in fact, I was going to jump in with a question, an unscheduled one here, because they're always much more fun because my fellow panelists are not expecting them. So this one was for Paul. Paul,
good.
Paul, because you know everything about company law and the way it's developed, how do you see company law changing to take account of 2020 AGM season and the 2020 Act and its application?
Well, there are two issues here. There's the substance of the law that we've been discussing here, and then there's the extension of the existing law. And if I just provide a little bit of background, which I think it'll chime with what John said about the reaction to the mode of communication at general meetings. I mean, AGMs fulfill three functions. Strictly speaking, they're to provide information to shareholders, to pass resolutions, and then for there to be interaction. And the communication of information is generally out of date. Professor J.K. Galbraith used to describe AGMs as resembling a Covenanted Baptist church service, where out-of-date information is presented to people. And then the resolutions are basically all rubber stamping exercises, in the sense that the voting has all, for most of the shareholders, has taken place by proxy beforehand. So you're left then with the interaction. Just to talk about that, when the Company Law Review Group prepared its COVID report, which is now up online, its approach was that the bill should, the Act would specify that there should be the ability for there to be communication, but the actual technicalities would be set out by regulation. As it happens, there was clearly a policy decision made that that there would have to be this requirement for shareholders to be heard, because that is the true value of an AGM. Now, mind you, it's for a minority of shareholders, because most institutional shareholders get their information from, roadshows, analyst briefings, and conference calls. So, in a sense, that if the law had been passed the way the Company Law Review Group had originally planned it, then maybe there would have been more virtual AGMs, but there would have been that criticism that has taken place. Interestingly, when it came to what was described in the report as restricted access meetings, the predominant view of the review group was in fact against them. And that was both from people in the market and from regulators and policymakers. So to answer your question, what's likely to happen? Well, it's my earnest wish, notwithstanding the lack of take-up amongst public companies as against membership organizations and private companies, it's my earnest wish that there will be an extension of the legislation which expires at the end of the year, such that it can run until June next. As regards to the substance of it, I don't, in the short term, envisage a change that would relieve companies from the requirement to have two-way communication at general meetings. I don't see that happening. As regards the continuance of the de facto restricted access meetings, they actually work as long as the quorum requirement is satisfied in a place and everybody else plays ball. It's really when there is dissent that there's a problem. Yeah. I think they're perfectly valid in terms of the proceedings that take place at them. The resolutions, they're all valid. But as Justin highlighted, if there were a predominant view against the convening of a particular general meeting on that basis, there could be a difficulty.
So to wrap up this section, and just remind people that they can submit their questions. We will have the open Q&A session starting shortly, so submit those while we're wrapping up the panel section. To go round the panel, or those who have any views on it, if, as Paul says, the virtual meeting provisions and others of the COVID Companies Act are extended into 2021, do we think that any of the experience of running AGMs in 2020 will change, or some of the features will continue into 2021 as a result of what we've done?
I mean, I'd happy to come in on that one, David. I think that's it's a good question. I mean, obviously, I think as Paul has alluded to, this is what will be important to see is if the current temporary legislation is extended into the next year to give those methods time to settle in people's minds, that'll drive to a degree that the change in behavior. I think if the technology is seen to be a success, and there's no reason to suggest that it wouldn't be, that'll be an important factor. We're already seeing certain changes of behavior in issuers' articles being updated. I think, and as well as that, there seems to be a drive more so for the upcoming AGMs and the volume that we will see for virtual being considered. It's saying that it may be the case that issuers go back to what they are used to, and computer share, as I think as John has alluded to, through our global business, we've seen a clear growth in virtual across the US and a massive shift there, and indeed Europe as well. But I think, John, I don't know from the point of view of the UK, there seems to be some surveys there that they may like to go back to the old methods if things settle back into the norm. But let you come in on that one, I guess.
Yeah, so we've conducted client surveys recently that have indicated that our client base would prefer to go back to physical meetings if given the option, but would consider hybrid as a alternative. And I think that's probably where most markets will progress towards. I can't see within Ireland or the UK that a fully virtual world, as they have predominantly in the US, will be adopted.
I'm going to slightly dissent in a subset of this and say that were I to be convening a meeting which was likely to be contentious, in other words, where there was a significant risk of a shareholder dissent, voting against or trying to disrupt, for example, a vote in favour of a transaction, I'd be moving towards a virtual meeting in compliance with the 2020 Act and not taking any chances on a closed meeting.
Yeah. Well, we might turn to some of the questions now, and I'd highlight some of them that have been coming in. You'll see them in the Q&A function. So a question coming from Michael Kerr. Regarding digital AGMs, is there any evidence yet of either meeting links being shared outside the usual AGM audience, or is there a risk of the potential for competitors to be able to gate crash another company's AGM? So this is the Zoom bombing phenomenon. My reaction to that is this is a concern that's very prevalent in Ireland and UK to a certain extent, I understand. Our colleagues in the US who've been running fully virtual meetings or remote participation for quite a while are much more relaxed, in my experience, with this idea. So this is the idea that you may have 50 members of Extinction Rebellion turning up on your oil company's AGM because they all share the link amongst each other. I think the experience in the US is it tends not to happen, more than they put extensive security provisions in place. But John, actually, you might talk about security. You mentioned shareholder reference numbers.
Yeah, so you're right, David. The US haven't seen any sort of Zoom bombing, but dependent on how you structure your AGM, and if you're using platforms like Lumi or one of their equivalents, there is pretty robust security to only allow in permitted members or authorized attendees. What we have started to see, though, is a trend, particularly through Europe, and I think it was kicked off by Shell this year, of conducting a wider sort of shareholder stakeholder engagement session and then allowing the proxy voting to end after it. So they've almost separated the two components of a meeting. And this is one of the recommendations in the UK that the Financial Reporting Council has put forward that I understand the GC 100 and likes are considering for future years.
Yeah. Does anybody else want to comment from their experience on that?
I'm not sure that the risk of competitors coming in on an AGM is of much concern, because what happens at an AGM tends to be pretty public. It is really down to Extinction Rebellion and the like, though, a disruptive as opposed to competitive influence, David. And I haven't seen any evidence of it this year. Well, there haven't been virtual AGMs, so it's difficult to say yet. I haven't seen any evidence of concern.
Okay, the next two. The first one, how the panelists believe 2021 season will be dominated by virtual meetings. I think we've already really discussed that. But a second anonymous question. It's disappointing that in this day and age, a board can get away with having no female members. Is there likely to be more penalties for this in the future? Paul, can I turn to you on that?
Well, probably not penalties, but there will be some developments on this. I think it's about 5 years ago that the Commission published a draft directive that would have required all companies admitted to a regulated market to have at board level 40% at least of what they in Eurospeak called the minority gender represented. But what we're speaking about here, with the exception of AIB, would be female representation. But as we know, things in Europe move at a glacial pace, and every year it has remained on the agenda. And most recently, I had to look at it a couple of months ago, it had been put back on the legislative plan for 2021, again on an urgent basis. But there's no move here in Ireland for there to be law. There has been sort of a genuflection of a sort in the UK governance code, where diversity is in there as one of the important criteria by reference to which board appointments should be made. But as regards penalties, no. But there is movement in this area. I think 29%. I think this year it's up on this year.
Yeah, I mean, that's the main comment. This is a comply or explain obligation, compliance with the UK Corporate Governance Code, if you're a company with a main market listing. And there's the guidance on board effectiveness, which goes into more detail on gender balance. So there's something that has to go into the annual report if those objectives aren't being addressed. Okay, so another person asking about any trends from 2020 in terms of ESG sustainability reporting / metrics in annual reports or at AGMs. It's not something we've tracked. We didn't look at annual reports this year. That's not the focus of today's study, but does anybody have any comments there?
I think in terms of engagement with proxy solicitation agencies and the like, this has become much more of a focus in terms of what they like to see boards focusing on. But there are no specific resolutions which need to be passed in that connection at the moment. So, but it's definitely something that's increasing as a focus and as a priority for all listed companies. And you'll find that there's commentary in this in all of the annual reports and chairman statements. So,
yeah. And I know proxy guidelines, it's something that they've been, if you look at the 2021 guidelines for ISS and Glass Lewis, something that they comment on now. So in Glass Lewis, they note that they'll note concern for FTSE 100 companies that don't provide disclosure against board level oversight of environmental and social issues. And I think for shareholder meetings after 1st January 2022, it will recommend a vote against governance chairs who fail to provide explicit disclosure on these areas.
And just to, for completeness, the SRD2 requirements, the shareholder engagement requirements now include for main market listed companies the requirement to engage, produce a shareholder engagement policy on social, environmental impact and corporate governance. So that's another obligation which is forthcoming. Okay, I think we're effectively out of time now, so I'd just like to thank everybody for attending and the panelists for their time and their contributions. And I'll hand back to Justin.
Again, just thank you very much for attending. I think that was a very discussion. We do have a couple of other questions, but One of them relates to what platform to use and whether it would be recommended. And I think we probably shouldn't do that at this meeting. So I think we'll conclude there. And thank you very much, Joe and John, for joining us. I thought your insight was very, very valuable. And I hope you all found it very interesting. And I look forward to our AGM report next year. And it will be extremely interesting to compare it to this year's one. Let's see what happens in the meantime. And if Paul would just kindly change the law in the meantime, that would be very nice too. So thank you very much, everybody.
Thanks, sir.
Take care.
Bye.
Bye.